Right now, in state capitals across America, lawmakers are quietly rewriting the rules of money, not with press conferences, not with headlines, but with quiet, deliberate legislation. 45 states have already moved, erasing taxes on gold and silver, restoring them as legal, constitutional money. While Washington keeps printing, while the national debt races past $40 trillion, state governments are preparing for something else entirely, something they are not saying out loud. And by the end of this video, you will understand exactly what they know that most Americans still do not. Welcome back to Currency Arc Insight, the channel dedicated to tracking the quiet economic decisions shaping the future of money before mainstream media catches up. If this is your first time here, subscribe now so you never miss a critical financial warning. Let us know in the comments where you're watching from today. In state houses across the United States, a legislative pattern has been unfolding that receives almost no coverage from national media, yet carries implications far larger than most Americans realize. Over the past several years, a growing number of state governments have moved to eliminate sales taxes on gold and silver and to formally reaffirm these metals as legal tender under state law. The pace has accelerated, the scope has widened, and the reasoning behind it traces back not to political trend, but to a single clause buried in the United States Constitution. Article 1, Section 10 of the Constitution states plainly that no state shall make anything but gold and silver coin a tender in payment of debts. For much of modern history, this clause has functioned as a historical footnote, rarely invoked and rarely understood. States, meanwhile, developed a practice that stood in quiet contradiction to it. Physical gold and silver were treated not as currency, but as ordinary consumer goods, subject to the same sales tax applied to furniture, electronics, or clothing. An individual could walk into a bank and exchange a $100 bill for 5 $20 bills without paying a cent in tax. That same individual, attempting to exchange paper currency for a gold coin of equivalent value, was in many states charged a tax penalty for doing so. This distinction, though procedural in appearance, revealed something deeper about how state and federal systems have quietly classified money itself. Paper currency, backed by nothing but government assurance, moved freely. Gold and silver, historically the most stable stores of value across centuries of civilization, were treated as taxable property. Business owners in the bullion and coin industry were among the first to recognize the practical damage this caused. Sales tax on precious metals did not eliminate demand. It simply redirected it, pushing buyers toward tax-free neighboring states or online dealers beyond a state's economic reach, and quietly draining local commerce in the process. What began as isolated complaints from dealers and investors evolved, over the course of several years, into an organized legislative movement. Advocacy groups focused specifically on monetary policy at the state level, coordinating with lawmakers to draft repeal bills, present economic research, and build the case that taxing constitutional money was both legally inconsistent and economically self-defeating. The results have been difficult to ignore. As of 2026, 45 of the 50 states have eliminated or partially eliminated sales tax on gold and silver purchases. Only 5 states continue to apply this tax in its original form, and legislative proposals to change that are already moving through several of their state houses. The significance of this shift extends beyond simple tax policy. When a state government formally repeals a tax and reclassifies gold and silver as legal tender, it is making a structural statement about the nature of money during a period of sustained currency expansion. The national debt has surged past $40 trillion. Federal spending continues at a pace that shows no indication of slowing, regardless of which political party holds power in Washington. Against this backdrop, state-level recognition of gold and silver as constitutional money is not an isolated legal correction. It is a quiet, methodical positioning by state governments, independent of federal policy, toward assets that have historically preserved value when paper currency has not. This pattern did not emerge overnight, and it has not unfolded through public announcement or dramatic policy shift. It has moved through committee hearings, procedural votes, and legislative sessions that rarely draw national attention, yet its trajectory is unmistakable. What is happening across these state houses represents one of the clearest signals available that a structural shift in how money is defined, taxed, and protected is already underway at the state level, well ahead of any broader national reckoning with the dollar's long-term position. The next part of this analysis turns to Maryland, where a single legislative misstep in the opposite direction offers a precise illustration of what happens when a state moves against this current, and how quickly the consequences forced a correction. If the broader national trend illustrates where state governments are heading, Maryland offers a rare and instructive counterexample of what happens when a state moves in the opposite direction. In 2025, Maryland lawmakers made a decision that ran directly against the pattern spreading through the rest of the country. Rather than easing the tax burden on precious metals, the state expanded it, Prior to that year, Maryland exempted gold and silver purchases above $1,000 from sales tax, a threshold designed to protect serious investors and small transactions alike. The revised law eliminated that exemption almost entirely, replacing it with a narrow and unusual carve-out. Purchases made in person at the Baltimore Convention Center remained tax-free, while nearly every other transaction in the state did not. The economic consequences arrived quickly and were far more severe than lawmakers appeared to anticipate. In-state bullion and coin dealers, many of them small, family-operated businesses that had served their communities for decades, reported sales volume declines exceeding 70% within months of the law taking effect. This was not a gradual erosion. It was a near-immediate collapse of local commerce, driven by a straightforward economic reality. Buyers did not stop purchasing gold and silver. They simply stopped purchasing it in Maryland. Neighboring states with no such tax became the default destination, and online dealers operating outside Maryland's jurisdiction absorbed the remaining demand. The tax did not generate meaningful new revenue for the state. It redirected existing revenue elsewhere, while leaving Maryland's own dealers to absorb the damage. The pattern that unfolded in Maryland reflects a broader principle, increasingly evident in state-level economic policy. Precious metals, unlike most consumer goods, are highly mobile and highly price-sensitive to tax treatment. A buyer purchasing furniture or electronics is often constrained by convenience, delivery logistics, or brand availability. A buyer purchasing gold or silver bullion faces no such constraint. The product is fungible, easily transported, and available from thousands of dealers nationwide. Any jurisdiction that imposes a meaningful tax penalty on these transactions is, in practical terms, exporting its own tax base to competing states, a lesson Maryland's dealers learned in real time. What followed was a legislative correction that moved with notable speed relative to typical state government timelines. Delegate Wayne Hartman and Senator J.B. Jennings, working alongside national sound money advocacy organizations, introduced companion repeal legislation aimed at restoring the prior exemption. Their effort was built on more than principle. It drew directly on the economic data emerging from Maryland's own dealer community, presenting lawmakers with a clear before and after picture of the tax's real-world impact. Senator Jennings later characterized the original tax as an unnecessary burden that extended well beyond the precious metals industry itself, rippling outward into the broader state economy through lost jobs, reduced local spending, and diminished business activity. The repeal effort succeeded, and Maryland's exemption was restored. For their work, Hartman and Jennings were named among the 2026 Sound Money Legislators of the Year, a distinction that places their names alongside a small group of lawmakers nationally recognized for advancing constitutional money principles at the state level. Yet the significance of the Maryland episode extends beyond the individual lawmakers involved. It functions as a controlled experiment, however unintentional, demonstrating with unusual clarity what happens when a state government positions itself against the prevailing direction of state-level monetary policy. The financial damage was swift, measurable, and difficult to dispute. The political response was equally swift, suggesting that lawmakers across the political spectrum have increasingly come to view precious metals taxation as a settled question, one where reversal carries real economic and political cost. Maryland's experience serves as a cautionary marker for the 5 remaining states that continue to tax gold and silver. It also reinforces a pattern that becomes increasingly difficult to dismiss as coincidence. Across the country, states are not merely tolerating gold and silver as alternative assets. They are actively removing barriers to their use, and in states like Maryland, actively correcting course when they attempt to do otherwise. The next part of this analysis moves west to Alaska, where lawmakers took the sound money movement further than tax exemption alone, formally reestablishing gold and silver as legal tender under state law. While Maryland's experience illustrated the cost of moving against the sound money trend, Alaska's legislative path reveals something more significant than tax policy alone. It demonstrates what happens when a state government moves beyond exemption and toward outright legal recognition, a distinction that carries far greater weight than most observers initially recognize. Alaska presented a unique starting point. Unlike most states, Alaska has no statewide sales tax, which meant the familiar battle over state-level taxation of precious metals did not directly apply. The vulnerability instead existed at the municipal level, where individual local governments retained the authority to impose their own sales taxes on gold and silver transactions. This created a fragmented and unpredictable landscape, where a buyer's tax exposure could shift entirely depending on which municipality a transaction occurred in. It was, in effect, a patchwork loophole running directly against the spirit of constitutional money, one that had persisted largely unnoticed for years. Addressing this required a different kind of legislative effort than Maryland's straightforward repeal. State Representative Kevin McCabe spent 5 years developing and refining the legislation that would eventually close this gap statewide. This extended timeline reflects the underlying complexity of coordinating a uniform standard across dozens of independent municipal tax authorities, each with its own local interests and revenue considerations. Legislative patience of this kind rarely draws public attention, yet it often produces the most durable and comprehensive policy outcomes, precisely because it accounts for structural resistance points that faster, more reactive legislation tends to overlook. The result of that effort, House Bill 1, was signed into law in May 2026. And it accomplished two distinct objectives that together mark it as one of the more consequential pieces of sound money legislation passed by any state to date. First, it eliminated local sales tax assessments on gold and silver coins, bars, and rounds across every municipality in Alaska, closing the patchwork loophole entirely and establishing a single, predictable, statewide standard. Second, and more significant, it formally reaffirmed gold and silver as legal tender under Alaska law. This second provision deserves particular attention because it represents a meaningfully different category of legislative action than tax exemption alone. A tax exemption addresses the cost of acquiring gold and silver. Legal tender status addresses something more fundamental, the legal character of the asset itself. By formally designating gold and silver as legal tender, Alaska did not merely make precious metals cheaper to purchase. It reasserted in explicit statutory language that these metals function as constitutional money under state law, standing alongside, rather than beneath, the federal dollar in the eyes of Alaska's legal system. Representative McCabe described the legislation as giving Alaskans direct access to inflation-resistant assets, while aligning the state more closely with the original intent of the U.S. Constitution, a framing that positions the law not as a modern policy innovation, but as a restoration of a much older legal standard. Alaska's action did not occur in isolation. Wisconsin lawmakers pursued a parallel, though procedurally distinct, path toward the same broader objective. Over a 3-year legislative effort, Representative Shay Sortwell and Senator Rachel Cabral Guevara worked to eliminate Wisconsin's sales tax on gold and silver entirely. That effort reached its conclusion in early 2026, when Governor Tony Evers signed Senate Bill 748, a measure that went further than tax elimination alone by also removing cumbersome administrative requirements that had previously complicated precious metals transactions for ordinary buyers. Both lawmakers received honorable mention recognition for their work, joining Alaska's Representative McCabe among a small group of legislators nationally credited with advancing sound money principles through direct legislative action in 2026. Considered together, Alaska and Wisconsin illustrate that the sound money movement sweeping through state legislatures is not confined to a single approach or a single region of the country. Some states have focused narrowly on tax repeal. Others, like Alaska, have gone further, using legislation to make an explicit legal statement about the nature of money itself. The consistency of direction across such structurally different states, one with no sales tax framework at all, another with a fully developed one, suggests a shared underlying motivation extending well beyond routine tax policy. The next part of this analysis steps back to examine the full national scope of this movement, the states still resisting it, and the emerging financial infrastructure suggesting this shift is moving well beyond legislative text and into practical, everyday use. Individually, Maryland, Alaska, and Wisconsin might appear as 3 separate, unrelated legislative stories. Together, they form a single, unmistakable pattern that extends across the entire country. As of 2026, 45 of the 50 United States have eliminated, or partially eliminated, sales tax on gold and silver purchases. This is not a narrow regional trend confined to a handful of politically aligned states. It spans nearly the entire nation, cutting across geographic, economic, and political lines in a way that few modern legislative movements manage to achieve. Only 5 states remain as holdouts, continuing to apply sales tax on precious metals purchases in their original unmodified form: Hawaii, Washington, New Mexico, Maine, and Vermont. What makes this figure significant is not simply the small number of states remaining, but the direction of movement within them. Sound money advocacy organizations tracking state legislative activity report that exemption bills are already being drafted or introduced in nearly all 5 of these states, with several expected to reach formal committee review during the upcoming legislative session. Barring unexpected political resistance, the gap between adopting and holdout states appears positioned to close further within a short time frame, potentially leaving only isolated exceptions rather than a meaningful block of resistance. This near-uniform national alignment raises a more fundamental question than tax policy alone can answer. Why would 45 state governments, independently and without centralized coordination, arrive at the same conclusion regarding the treatment of gold and silver within a relatively compressed period of time? The most plausible explanation lies not in any single piece of legislation, but in the shared economic environment all 50 states currently operate within. The national debt has surpassed $40 trillion. Federal spending continues without meaningful restraint, regardless of which party controls Washington. Inflation, even when officially reported as moderate, continues to erode the purchasing power of the dollar over time. State governments, responsible for their own long-term fiscal stability, appear to be responding to this environment by removing structural barriers to assets that have historically retained value independent of federal monetary policy. This shift is no longer confined to legislative text. In several states, it has begun extending into functional financial infrastructure. Texas, for example, has established its own state-administered bullion depository, a secure storage and transaction facility often described informally as the state's own version of Fort Knox. This infrastructure allows the state, and by extension its residents, to hold and transact in physical gold outside the traditional federal banking system entirely. Separately, instruments such as the Goldback series, a physical note whose value is directly tied to a fractional weight of gold, have begun circulating in limited but growing use as a spendable gold-backed alternative to paper currency. While these instruments carry a premium above the raw value of the gold they represent, that premium reflects their function as usable currency rather than pure bullion, a distinction that has allowed them to gain modest but real traction as a transactional tool rather than a purely speculative asset. None of this suggests an imminent collapse of the dollar in the immediate term. State governments are not signaling that the dollar will fail tomorrow, next month, or even next year. What they are signaling, through a consistent, multi-year, nationwide legislative pattern, is a quiet erosion of confidence in the dollar's long-term stability as the sole viable form of money. Legal tender laws, tax repeals, state-administered depositories, and gold-backed transactional instruments do not emerge from short-term political calculation. They emerge from institutions preparing methodically for a slower, more gradual monetary transition, one measured in years and decades rather than headlines and news cycles. For the business community, entrepreneurs, and individuals tracking the broader economic landscape, this pattern carries a clear implication. When 45 state governments move in the same direction, independently and without centralized federal coordination, the signal extends well beyond any single tax bill. It reflects a structural repositioning already underway at the state level, well ahead of any broader national reckoning with the dollar's position, and well ahead of when most individuals are likely to notice it on their own. Ready for the final part when you are, the concluding section that ties this national pattern directly back to what it means for the individual investor and business owner watching today.